this should be information that underlines what we need to do to move this country forward. Good afternoon, everybody. It's David Leis, and a warm welcome to everybody as you join this live presentation on Leaders on the Frontier as we talk about important issues to Canadians. Canada is an incredible country, and we have, I believe this is a historic time, and we are going to dare to go into one of these, I believe, a seminal decision that relates to the Cowichan decision in Richmond, BC. And you may say, well, I don't live in Richmond, and I don't live in British Columbia, and therefore this doesn't mean anything to me. I believe you're wrong. And so we're going to have that debate and discussion. We're going to parse it down and try to understand from a thoughtful policy point of view what is really at stake here. So a good afternoon to everybody as we look on this November 27th, 2025, the year of our Lord. So as people come on, we are so thrilled by the kinds of, well, thousands of letters. Hello, David, from Matthew. And thank you so many people who are regulars on Leaders on the Frontier. I want to share some comments, and we value them greatly. What a great video, very educational. Thank you. I will be sharing this with many property owners here in BC, and I believe that was in reference to this past week where we issued yet again another episode. I believe it was last week with senior fellow Bruce Party about this issue. I encourage you to look at that and check out those things. Other comments. I very much appreciate that you have real academics and guests with a background that makes them credible. I've gotten pretty tired of anyone with a mic posting rage bait. Very well done interview. And thank you so much for that comment. Yeah, we hope to elevate the level of thinking and analysis here. We're not looking for bait, but we are looking for facts and truth and good analysis. We've got a lot of things going on in the news, and one of them I want to highlight is from today's announcement regarding a MOU, a Memorandum of Understanding between the federal government and the province of Alberta. And you can see the Prime Minister shaking the hands of Alberta Premier Daniel Smith as they talk about many issues. So what are some of the highlights within that MOU? It's hard to know exactly whether this will move the needle as we try to get our economy going forward and improve our management of natural resources. But the punchline is that this summary is from the Alberta government. It says no oil and gas production cap, no net zero power regs, new 1 million plus million barrels per day, a pipeline to Asian markets, 400,000 barrel per day TMX expansion, and a deep water port access for oil tankers. So there you go. That's a high level summary. And those appear to be promising signs, because obviously one of our ace cards as a country is reliable, affordable energy. Let's get this economy rolling. I also want to share another story that caught my eye, and this is in Waterloo Region, where there was a school board a court case that's being tabled, where the school board is being hit with a legal challenge over forced land acknowledgements. Go figure. So there's quite a background there. And I believe that picture features a parent who said, you know what, you can't force me to do this, and this is simply a violation of my charter rights. I also want to highlight the sad story just south of the border in Washington, D.C., where a suspect is now being held in custody for ambushing 2 National Guardsmen. And apparently this is an Afghan national who entered the U.S. during a previous presidential admission, and that's from the Washington Free Beacon. So we'll see what the significance of that story is and how that unfolds. Another very interesting clip I want to share has to do with Saskatchewan and the incredible company, Nutrien, and its decision to not go with a coastal port facility in Canada, but to go to a Washington state facility.
License is being blocked.
Saskatchewan potash was a priority during question period in the BC legislature.
Nutrien just chose Washington State for over $1 billion project, driven out of this province, walking away for an opportunity for people in this province to prosper.
The opposition hammering the government over revelations a major Saskatchewan potash company was planning to build a massive terminal near Vancouver, Washington, not Vancouver, BC. News that also rankled the Premier.
It is unacceptable. It is deeply disturbing and problematic that Nutrien decided to go to Washington State instead of coming to British Columbia.
The company, Nutrien, says in picking Washington State over a port in BC like Vancouver or Prince Rupert, it assessed 30 criteria, including port capacity, noting Port of Longview best met the technical and commercial requirements. It's designed to complement our existing Canadian port capacity and to support long-term production growth in Saskatchewan. Energy Minister Dick says Ottawa isn't listening to BC's pleas for expanding its ports.
Well, we've been making the case to the federal government for the need to invest in ports, to expand our capacity in ports. This is a major priority for BC.
But the opposition blame an uncertain investment climate in BC flowing from Indigenous land claims, and also say the NDP should be pushing Ottawa harder on port expansion.
We should be looking at getting rid of the thermal coal out of Vancouver that's coming out of the United States as a way to be able to leverage against Americans. So we had options that we could have looked at.
The attacks came from Saskatchewan, too. Its premier blaming the decision for Nutrien to go south on Premier Eby's opposition to Alberta's proposed pipeline to the coast.
So there you go, a news clip regarding that decision. What do you think? Should a company like Nutrien make those decisions on 30 criteria? And apparently on all 30 of them, it came up to be that decision in Washington State. So we live in a competitive marketplace, so let's pay attention to that one. And then I want to just move quickly now into the topic at hand. We've got an extraordinary panel, and I want to introduce them. Bruce Hallsor is a managing partner at a prominent law firm in Victoria. I believe it's the oldest firm. Is that correct, Bruce?
We believe we're the oldest firm in Western Canada.
It's really quite remarkable. And I know that you have argued many cases at all levels of the court, all the way to the Supreme Court. So a warm welcome to you, Bruce.
Thank you.
And of course, Brian Giesbrecht, a retired judge, and he is a dynamic senior fellow at Frontier. You probably have not missed his, you have noticed his many analyses and thoughtful columns. So a warm welcome to you, Brian.
Thanks, David. Nice to be here.
And of course, a regular Dr. Marco Navarro-Genie, who's the Vice President of Research at Frontier. Good to see you, Marco.
Good afternoon. Thank you, David.
So we've got a powerhouse of a panel here, and we've got a lot of background that's unfolding from that August decision called the Cowichan decision, where a judge, I believe it's the justice from the BC Supreme Court, Barbara Young, made the decision that indeed, given that title claim of property in that area, that the Cowichan tribe should have claim to some 800 acres. And this decision is reverberated across the country. So I want to turn to you, Bruce, first of all. Was this a landmark decision? And if so, why?
You know, in one way it was. It definitely was a landmark decision, but it wasn't, it shouldn't have been a surprise to people who watch legal trends in this area. It's a landmark decision because it's the first decision respecting native title and fee simple land. And that, of course, is a game changer for a lot of people. It's not a landmark decision in the fact that Aboriginal title as a concept has been recognized, and it has been recognized in other cases that Aboriginal title theoretically could be superior to, or at least equal to, Crown title on non-raised lands, non-fee simple lands. You know, what's different about this is it seems like a lot of people who should have cared didn't worry too much when courts decided that Crown land, mountaintops and wilderness was in jeopardy of public ownership and is going to be co-managed. But all of a sudden, people look a little differently when it's your house or the building you work in or commercial properties. 5% of the landmass of BC is fee simple, and 94% is Crown land. So this is an issue that has been slowly coming for 30 years, but it's hitting home. in an urban area for the first time.
Oh, so there you go. It's hitting home. And it's, if I understood your comment correctly, Bruce, this has been a long time coming, but we just haven't quite noticed it until now when you have a whole raft of, well, people in that affected area are claiming that they can't get mortgage renewals. Is that what's happening?
Well, we don't know we haven't seen the data yet. It's early to know. We've heard anecdotally that some people have had trouble getting mortgage renewals. And of course, that makes sense. You have a Supreme Court of British Columbia telling everybody that land, at least in that area of Richmond, and by implication, a lot of other land across British Columbia and Canada, but certainly in that claim area, that land is subject to a senior title by a First Nation on Vancouver Island. And it's very undefined as to what that means. The court didn't clarify or resolve it. They just said it exists. And it's superior and senior to the fee simple owner. So if I'm a mortgage lender or I'm a buyer looking to purchase real estate, I would probably want to stay out of that uncertainty. Uncertainty is the death of markets. And although we don't know exactly what the impact is, there's an impact for sure.
Exactly. Yeah, indeed. And I think your comment about how foundational property rights are in this country are well said. So thank you, Bruce. Turning to Brian Giesbrecht, what's your take on the significance of this decision? Is this a landmark decision?
Yeah, and I think it's it's a frightening decision in many ways, and I think Bruce is absolutely right that the reason that people are really taking notice is because this involves their title to their homes. That's sacred to people. But we do have to think, Bruce made reference to 94% of BC being Crown land. We have to think about that other land as well, because we've already seen instances in Manitoba as well as BC of non-Indigenous people being excluded from provincial parks, for instance, for periods of time in Manitoba. It was quite a long period of time. Well, how are people going to accept that if more and more areas are designated as Aboriginal title? This is a profound change, and I'll just make mention of a couple of recent cases in Manitoba on Aboriginal title, because it's been being said by many people that, well, we don't have to worry about those treaty areas, but I don't think that's correct. We have, as you know, we've got 2 Dakota Sioux community Indian bands now suing for much of Winnipeg, the Forks area. They're suing for ownership of the oil-producing parts of Manitoba, parts of Saskatchewan and Ontario as well. And those are the Sioux who were never covered by a treaty. But meanwhile, we've got the senior, I think he's the senior Manitoba chief, basically saying that, well, the treaties aren't worth the paper they're written on, because you have the treaty chiefs now looking over at what's happening in BC and realizing how lucrative those claims are going to be. And so wanting exactly the same thing. So I think what we're going to see is not just BC, not just New Brunswick, not just Nova Scotia and Quebec. This is going to really be, I don't want to be alarmist, but I think this is going to go across Canada, because the possible outcome is so lucrative for Indigenous communities that nobody's going to be able to resist.
Wow. So we've got a lot going on in this country, and I think those cases that you referred to in terms of access to Crown land, I think is well illustrated by the challenge of the Bloodvein First Nation in Manitoba, where they are putting up blockades and preventing licensed hunters from accessing those lands. And I think you've given analysis to that, Brian. Help us understand what's going on there.
Yeah, this has been going on now for a few months, where the Bloodvein Indian Band has set up blockades and is preventing ordinary Manitobans with hunting licenses stopping them from going on the land. And there's a lawsuit right now pending from the hunters saying we just want to do what is our right as citizens, and we have bought our hunting licenses, but the province is refusing to back them up. So what you have, and I think this is going to be in BC as well, where you see the provincial governments, the provincial premiers, at least some of them, Eby and Canoe for sure, are not going to be taking the side of the fee simple owners and the ordinary citizens. They are, for political reasons, going to be giving in to the indigenous activists on this. So that's what's happening in Bloodvein, and those hunters are not allowed on the land, and the province is refusing to help them. So it's quite shocking. I think, at least I am shocked by this.
Well, I think your comment, Brian, is very telling, and also your allusion to the reality that even though, let's just take the Cowichan decision as example, it's being appealed by the city of Richmond, by the BC provincial government and other parties, including competing claims from other First Nations, interestingly enough. It's being appealed, but the question you're alluding to, Brian, seems to be that we would think that these governments would have had our back, namely the provincial governments, but they've kind of enabled this over a period of years, including the Supreme Court of Canada. Is that a fair comment, Brian?
It's worse than that. It's worse than that. Bruce probably would have more information about the practice directives that are now really limiting the ability of the justice lawyers to bring the best arguments forward in court. And I've written on that, David, in the past about Jody Wilson.
Yes.
Raybold's practice directive, but now BC has their own practice directive. And basically what it means, and Bruce will have a better answer than I do, but basically what it means is the government lawyers go into court with one hand tied behind their back, basically, and they're often not putting forward their best arguments. So not only do you have provincial premiers pussyfooting around and not wanting to put forward their best case, but you've got these UNDRIP and DRIP of practice directives, which are further limiting the ability of the governments to make a good case. And you have basically, Bruce might disagree with this, but you basically have blinkered judges. That's what you have. So in the Cowichan case, for instance, you've got Justice Young, and she may not even be getting the best arguments from the lawyers. So she may be, really, they talk about blind justice. Well, in this case, the judges are at least partly blind, because the lawyers, the government lawyers, are not able to advance the strongest cases. So that's what I fear will happen in this Cowichan appeal, where they will make a very weak appeal, and the result will not be a very good one.
All right. Thank you, Brian. I want to turn to Marco. I just want to notice we've got a lot of comments coming in from the audience, and we really appreciate them. But I noticed that Sheridan Forbes said an interesting comment here about the importance of property rights. But basically, sadly, without property rights and only property privileges, Canada will not attract capital, and the standard of living will continue to drop in Canada. So thank you for that comment. So turning to you, Marco, what are your thoughts? Is this a landmark case, and why?
It absolutely is, although I'm not qualified to speak about the legalities or illegalities, constitutionality of what is taking place. But from a sort of political science point of view, or from an economic point of view, this is a bit of a disaster waiting to happen. It is a disaster for the people onto whom this is being inflicted. Let's put that clearly. But should this propagate, and there are mechanisms by which this could propagate through precedents in the courts and what have you. Property is the cornerstone of liberal democracies. You look around, and in every place in the world that has anything that looks meaningfully like a liberal democracy has the establishment of property as a cornerstone of its political system. Um, it doesn't necessarily have to be a property right in the sort of written sense of the term. Uh, Canadians worry about that all the time, and we have lots of arguments about this. That there are no property rights in Canada, that there are no written property rights in Canada, that they're not included in the written constitution, but they are part of the tradition going back hundreds of years. And
Mhm.
so, in that sense, the idea that the government or anyone else can come and seize your property without your consent or what have you is abhorrent to our culture,
Mhm.
whether it is written in the Constitution or not. So, in that sense, uh, this is a landmark case because it establishes, as Bruce quoted at the decision, superior and senior rights to specific group. And this is anathema to also the principle of equality in a liberal democracy.
Mhm.
About 20 years ago or so, one of the most prominent political scientists in the country, Alan Kearns, who also happened to be from BC, wrote this book called Citizens Plus, making the argument that perhaps Canadians should think about granting some kind of upper status to certain kind of Aboriginal groups and a different class of citizenship, in a sense. So that argument has been arriving for a long time, and this is in part, as Bruce pointed out, in some ways the culmination of it.
Wow, what a powerful summary, Marco, and your reference to the late great Alan Cairns. So, Bruce, I want to turn to you, and I know that you're on legal deadline here, but we look at this case. Is Marco's analysis a flag for you that we are indeed seeing the arrival, the birth of Canadian Citizens Plus here, as we have almost two
Well,
classes of citizens?
I actually, a point that Brian made ties in with that exactly, because Brian made the point that most of the lawyers' hands were tied in arguing this case because they ignored a whole bunch of possible arguments that could have been advanced that were not. And one of those is Section 15 of the Charter, equality rights, that all Canadians, regardless of race, should be treated the same, without some reasonable and justifiable means. Well, that could have an impact on this case, was not explored at all. The judge found that private property rights, as we understand them, are not protected by the Charter, but that Aboriginal rights are. And even that is an issue that could be argued. The Charter is not the only source of rights in our society. Before the Charter existed, we had rights. Property rights are a common law property right of ancient origin that are a fundamental building block. Nobody argued that. We have a Torrens land title system in British Columbia that guarantees indefeasible title. Richmond tried to argue that. The senior governments really did not. But even the impact of Section 35 of the Constitution Act, Section 35 of the Constitution is not part of the Charter. It's part of the administrative side of the Constitution, and it simply says that we have to respect existing Aboriginal and treaty rights undefined. That doesn't automatically lead to property rights on this case, and it doesn't automatically mean that indefeasible title and common law constitutional property rights shouldn't be respected, especially when you think that there is a section of the Charter, Section 15, that warns us against setting up separate title systems based on race. So none of these things were argued, and hopefully they will be on an appeal. I'm tangentially involved as a potential intervener on the appeal, so I can tell you it's going to be a long time before any of these arguments get to court, and there's a possibility that the trial might even be reopened by private landowners who were excluded from the trial, not even given notice of the trial. So lots of things are going to happen on the judicial side that it's hard to predict. But for sure, nobody made an argument to the court that under any circumstances Canadians should be treated equally, and nobody really made a strong argument to the court to defend the constitutional position that property rights arguably do have in this country. And certainly there are statutory rights of indefeasible title that were given very little weight by the federal crown or provincial crown in argument, and should have been.
Okay, so I think that revelation would probably shock most Canadians. And I think this goes back to the comment that Brian Giesbrecht said. These are referred to as practice directives. In other words, it's a policy that the governments of the day are directing their lawyers in terms of how to respond to these types of challenges. Help us understand what a practice directive is.
Well, I'll give you a historical example of one. The Delgamuukw decision, which is one of the precedents that was used in this case, was won by the province of British Columbia at the trial level, and essentially said that Aboriginal title is very hard to prove and did not exist in that circumstance. And even if it does exist, it would be subordinate to the crown expression of sovereignty over the land, which was unchallenged when the first Land Title Act was passed in the colony of Vancouver Island in 1860. But in between that successful defense of property rights in British Columbia and the appeal, there was a new government in British Columbia. The government of Mike Harcourt got elected, and they they fired all the counsel who had won that case at the trial, and there was an appeal with new counsel, and they had new instructions, and their instructions were to accept Aboriginal title as a premise and not to do anything to oppose that. And that's how we ended up with the Delgamuukw case. The Court of Appeal in BC and later the Supreme Court of Canada were quite clear in Delgamuukw. Well, since the province has changed its position, the trial decision is untenable. And since everybody's conceding that Aboriginal title exists, the only real issue there was, what does it mean? And how do you prove it? It was conceded that it exists, even though a trial case had said it didn't. So this is an issue that goes back farther than this case.
Gosh, this sounds like a big legal reckoning. Mm-hmm. Not only that, but also a reckoning in terms of, well, what kind of citizenship structure and sovereignty we're going to have as a nation. So just before you head off to the courts, Bruce, I did want to clarify a question here. And it's one that was raised by the audience, by certainly a colleague, Joseph Cronell. Actually, that's another question, Madam Producer, I want to bring up here as well. But the one from Joseph Cronell was interesting. And basically, it goes to the idea that some are arguing on this case is that the two can coexist. You can have property rights fee simple, but you can also have Aboriginal land title as well. Help us understand, can they coexist? Is that viable?
Well, it reminds me of the scene in Dr. Zhivago when doctor comes home to his house and finds the government has let a bunch of other people live in it. And of course, he agrees that this is a much more democratic way of using it. But, this is we don't know what that means. But, if more than one person has an interest in the same land, they have to negotiate how that land is going to be used and occupied and what the benefits are coming from that land. And for somebody who paid good money to have fee simple title and thought they had all the rights, to have somebody else come in and have different rates undermines our entire system. How do you know if you can build development on a property or grant an easement on a property or sell it or even occupy it if you're not the sole title holder?
So this is the question. So I want to go back to you, Marco and Brian.
I'm going to jump off. I have to leave. Thank you all.
Great to see you, Bruce. We'll be in touch. So on this note, I mean, Bruce kind of summed it up that we're kind of in this limbo of uncertainty. And I mean, Marco, could you speak to, you're a political scientist. You have a lot of insights on the policy impacts on our economy. Where is this going to go in terms of our country? I mean, we're very concerned about Canada, frankly, being a kind of a sluggish, flat economy the last decade and a declining standard of living. What kind of cloud does this have over our country?
Well, there are a couple of reasons as to why land and the ownership of property are crucial to the foundation of liberal democracy. One of which is that when people own their own means, to use Marxist terms, their own means of production, their own land, their own businesses, then they are in mind and body independent from the state and the society in which they live.
Mhm.
If they do not, they are the opposite, right? They are dependent on the community. And therefore, one of the great sort of leaps in Western history in the past, 400, 500 years is that we went from serfdom, in which the laborers essentially belonged to the land,
Mhm.
to the idea that people can own their own little plot of land. And even in Europe, those two systems coexisted for a while. And in places where people owned their own land and could exploit their own labor, people did well and people did better and people had more or acquired more political rights. So that's one fundamental one. But the other one is the decision making ability and what you can do with the land. There is a now famous economist from Peru. His name is Hernando de Soto, who 25 years ago, actually, it's the anniversary this year. He wrote this book entitled "The Mystery of Capital." And De Soto kind of noticed that around the world, places in which people had title to their land. Now, people can have land and not have title, but when people have title, then they can use that title to leverage the value of the land to obtain loans and to put pigs and cows on the land, to put up a hotel, whatever. So it lends itself from that leveraging lends itself to the development of capital.
Mhm.
We see it in Canada. This has a direct application in Canada because in Aboriginal reserves, um, the Aboriginal community has title, but not the individuals. And so that land is what De Soto would call dead capital. Is not land that can lend itself to a significant amount of development, precisely because there's too many people making decisions, and it's a community thing, and what have you. So if we are going to communitize the entire country in that way, this will have significant repercussions for an economy and the way of life in this country. So there is an infinite number of reasons. Those are basically the two most fundamental.
So, Marco, I think you make many profound points. Your phrase, I think, is very instructive as you reference DeSoto, is that without these property rights, as you communitize, as you use that phrase, land, gosh, where does a capitalist economy go forward? And as you know, that's foundational to our prosperity and our freedom. This is incredibly concerning, and I do know that it's certainly sending shockwaves through the real estate economy here. So we'll have to wait and see. Um, and I did have, Madam Producer, an interesting question that was posed by the audience that is very interesting, because we're obviously trying to talk about solutions and remedies to this pickle that our country's now in of uncertainty. Is can the Bill of Rights and Freedoms be amended to include property rights for all landowners, not just Indigenous peoples? What's the process? Is it too late? It's ridiculous that it was taken out of the 1982 constitutional draft. I can't believe there wasn't an uproar over this back then. And that is from somebody named Goosebumps. So, Brian, do you want to take a shot at that? I know Marco, you could too. But is that a remedy? Is that what we're getting at? Is incorporating it into the Constitution? It's amazing. And I know, Marco, you have a lot of history on this as well. Do you want to go at that first, Brian?
Yeah, sure. I think what happened back in 1982, I was a judge then, and I was kind of shocked that it had been taken out, and then Section 35 had been inserted it wasn't expected to be there either. So
And just
I
remind us,
understand.
what is Section 35
Oh, sorry.
again?
Section 35 is the section that says Aboriginal rights will be preserved. Now, there's a whole hour-long thing I could do on that one too, because originally that wasn't supposed to be there, but they were persuaded to put it in by some very clever Indian chiefs who did a very good job in making their case. But even then, the premiers, the senior premiers at least, like Peter Lougheed and Sterling Lyon, were very firm. They did not want some type of section that could be used by some activist Supreme Court to expand Aboriginal rights, just as has happened since 1982. Delgamukkw is a perfect example of that. But they would not sign. They refused to sign. And finally, they were persuaded by the insertion of the word existing. So Trudeau said, no, we'll put existing in, and that will make it very clear to any future Supreme Court that they are not to meddle with that. So that's how existing Aboriginal rights, that is Section 35, got in. That's what makes this Aboriginal title a constitutionally protected right. The Supreme Court was not expected to do it, but they did, and they, in my opinion, the Supreme Court has made a terrible mess of things in how they've greatly expanded these rights to the point where personal property is now under threat. But the constitutional protection of private property, well, that was supposed to be. That was in the original draft, and we like to pick on Pierre Trudeau, but he had that in the original draft. That was expected to be. Property was expected to be constitutionally protected, like it is in the United States. But some of the premiers and the NDP party under Ed Broadbent back then didn't want it in. It's a very complicated argument that they had, but that was a terrible mistake, because the premiers should never have agreed to put Section 35 in and constitutionally protect those rights and take out the constitutional protection for property rights, but they did. So that's what we're stuck with now, and that's why Justice Young, and I think the interpretation actually is correct, as things stand, the Aboriginal title is a senior property right, and the fee simple, amazingly, is a junior right. So I think that's where we stand. I don't know if Marco has a different interpretation of that or not.
No, I do not. In fact, I think that's quite correct. I would add a couple of things to that. In the small C conservative movement, this man named Peter Lougheed has achieved a kind of sainthood, in part because he stood up against Pierre Trudeau on several things, and one among them is the patriation of the Constitution. We got to remember that Pierre Trudeau wanted to patriate the Constitution on his own, without the involvement of the provinces, and the provinces, a group of the provinces, took him to Supreme Court and blocked him. Peter Lougheed, one of the first things that Peter Lougheed did when he came to office in 1971 was issue an Alberta Bill of Rights that precedes essentially the Charter of Rights. The Charter of Rights is a federal document, and many, including the opposition, of whom Preston Manning's dad was the leader at the time, pressed him and insisted that property rights be included in the Bill of Rights for Alberta, and Lougheed shut them down. So by the time Lougheed gets to the patriation of the Constitution in 1982, he wasn't going to start pushing for property rights, and in fact, he did not. So of the many things that Peter Lougheed is, he was a defender of Alberta in many ways, and but I hold him in some ways responsible as one of the main negotiators of the what we now know as the Constitution Act of 1982, that property rights were not included.
Interesting background. So it's been a long historical journey to where we're at today. And so that's why I'm just so intrigued by this case, because it all seems to be coming to a head. And that's why I used earlier the word reckoning. Are we at, is that a fair description, gentlemen, of where we're at? Because it seems to me that if we don't have property rights, we don't really have a bright future as a nation, as much as we wish it ain't so. But you have to have stability. You have to have property rights. And so, so that's really describing the significance again, that this is a landmark decision. So where is this, how is this going to play out? Do you have a crystal ball, Brian and Marco?
No, I wish I did, but there are, I've heard a number of suggestions about how to deal with this. And one idea was from one person was to, from Dwight Newman, was to have this limited constitutional amendment. I won't go into how that's done through Section 43, but perhaps there could be a very limited constitutional amendment, not involving the usual 57 formula where you had to have 7 provinces with 50% of the population. So that's one possibility. Another possibility is, yes, just open up the Constitution. We need a constitutional debate about a lot of things. As you know, I'm completely with Bruce Pardy when he says we've got to get rid of all of this separate status stuff. And we have to find a way to get Canada moving along to the path of getting rid of all of these weird Indian rights that we've allowed to develop. We should be a country that has one set of laws for everybody. So, I mean, that's the grand scheme. We would have a constitutional debate, and it may come to that because this is that serious. But the other possibility is that the Supreme Court reverses itself, or at least partially reverses itself on the whole Delgamuukw line of cases, because, as I say, I think they've made a terrible mistake. They've, and I don't want to go too far into the oral evidence here, David, but I'll just mention this to you because I don't think you heard this before. But as you know, in Delgamuukw, what they did, the court said, well, we're going to allow hearsay evidence from 200, 300 years ago, as long as it comes from an Indigenous person. This was absolutely incredible. So in the Cowichan decision, for instance, the judge was considering evidence that, considering as reliable evidence, claims of conversations in a blueberry patch 185 years ago. Now that, it's totally preposterous. And it gives Indian claims some type of magical status, and the idea that Indian hearsay is admissible where all others is not is pure nonsense. And they've got to deal with that. But I'm just going to mention that because I've spoken to you so often about the Kamloops graves claim. Well, the reason that was taken seriously, or one of the reasons, is because this idea of Indian oral histories, stories in the community, the knowings and that sort of thing have some sort of magical status and are considered to be reliable, where claims from any other ethnic group would not be considered reliable. So it's actually warped our thinking in a way, and it's even affected what people are taught, what our kids are taught in schools, and what adults are taught in universities. And they have this idea that because it's Indigenous, it's somehow magically different than the stories from any other community. So my solution, as you know, I've been going on for years about the need to get rid of the Indian Act, the reserve system, and all vestiges of this Indian apartheid system we have built up, because this Cowichan case is just the sort of the culmination of all of that wrong thinking that we've been doing for years. But whether the Supreme Court is going to make any major change, I don't know, but that's years off. unless there's some sort of special reference to the Supreme Court, and I've seen no evidence of that. This is many years off, and Marco's comments about the uncertainty, I echo that completely. We put ourselves in a terrible position here. And probably what we're going to see over the next number of years, if I did have a crystal ball, is we are going to see governments paying off various Indian bands for all kinds of Aboriginal title claims. And with our debt situation, the idea of coming up with hundreds of billions of dollars to pay off all of these claims, it's unsustainable. So at some point, there is a breaking point. At some, whether we're there now or not, I'm not sure. But there is, at some point, something very serious has to be done, because the present path we're on is not a good one, and I don't think this is sustainable. These Aboriginal title claims are popping up all over the place. Here's a statistic for you, David. You'll like this one. You won't like this one. According to the Yellowhead Institute, which is now known as the only Indian think tank in Canada, there's something like 45,000 existing Indigenous claims in the system. 45,000. That's what I checked that up, and that's as of a few years ago. There might be more now, but the courts are absolutely swamped with these things. The Trudeau government has been settling these cases left, front, and center for billions of dollars. That's why we're what the contingent liabilities are at $70 billion extra. So things are very serious, and I'm regarded as an alarmist because I'm saying things like that. But I don't believe it's hyperbole. I think I think we're in a very bad state.
We really are. So I want to just take a little bit of a different path here, because we've heard a lot of key summaries. I mean, this case will continue to unfold. It's under appeal, and there'll be continued debates about the significance of this, and we'll see how the market responds. And people are finding out about this. Many Canadians are not aware of this issue, but sooner or later, more and more people will wake up to this reality as it hits home on people's property rights and freedoms. So I want to take a little bit of a different tact here, Marco and Brian, and that relates to this whole cause of reconciliation, because it's often been expressed concern that somehow, well, quite frankly, we know that we want all Canadians to get along together in prosperity and peace. But the concern here is that this decision is, quite frankly, a major fork in the road here. And I don't mean to sound, just kind of cheesy and rhetorical here, but this is a significant decision. And so the concern has been expressed by some, Marco, that somehow this is going to undermine reconciliation. And I'm frankly not clear how you define reconciliation. Often it's one way. But what is your comment about that? I mean, is this a point where we'll be finally reckoning again with all these big issues, including this whole reconciliation path that we've been on now for quite some time, where it seems like we're all guilty, we're all settlers, and it begs the question really of larger issues around what does it mean to be Canadian?
I'm going to say something controversial. What we are seeing is a revolution. Revolutions, we tend to have this idea that revolutions are conducted by people in fatigues with, black berets and cigars hanging out of their mouth when, people running around jungles. The definition of a revolution is actually the upending of the way in which we understand order, whether it's political order or political reality or what have you. And that's what we have in front of us. At issue here is a revolution in the way that we look at the world and we look at government. We no longer look at government as a sovereign institution. We are essentially chipping away at it from several different places. And so the order and the sovereignty of the country that we know as Canada really has ceased to be in the way that it was originally erected in 1867. At issue also is the idea of rights and where do they come from, right? So we tend to think that this is going to be solved by giving people property rights. I submit that it will not be, because rights are not being respected as we have them to begin with. We write them down, and some good has done. Look at the COVID fiasco, and everything else. So it's also an epistemological problem in the sense that where do rights come from? The American Constitution, we don't like to talk about American things in Canada, but the American Constitution says that these rights have been endowed to us by the Creator, right? Life, liberty, and we talked about this the last time, the pursuit of property. So either we have these rights and they are inherent to us by the dignity of being human, or they are state granted. And if they are state granted, then the government gives them, and the government can also take them away. So that's the second issue. The third issue really is that reconciliation. To come back to your question, reconciliation is an act of friendship, right? And friendship, our friend Aristotle reminds us that friendship can only be established between equals. If there is no equality between two people who call themselves friends, what you have is a dynamic of power. And so the revolutionary act here that is being perpetrated is what scholars called a role reversal. We believe that the Indians were once upon a time oppressed, and the role reversal is now that the Indians are becoming essentially the oppressing power. Friends do not exploit each other through power. And so, and friendship is necessary in order to have a political community. So that's out the window. What remains is power. I don't have a crystal ball, but I can tell you that relationships that are only settled by power never end well.
Well, there you have it, Marco. What a summary, and I believe a foreshadow, a warning to us all in terms of what is really happening here, the significance of this. So well said. Brian, any comment?
Yeah, no, that was very interesting, and just on reconciliation. When this whole thing started, when the plan was reconciliation, I think a lot of people, a lot of Canadians, non-Indigenous Canadians, said, "Okay, we have not treated Indians well. There are many reasons why we should make it up to them, and we should be doing things differently. We have to improve, and so we want to participate in reconciliation." Now, if you had that from the other side, if the chiefs, for instance, had also honestly looked at what they had been doing, and if they said, we have made a big mistake, we have just tried to shame and blame Canadians and ask for tax money. Why do we have 5% of the population and a fraction of a percent of the graduated engineers, doctors, etc.? Why aren't we doing better? And if they had looked at themselves before saying, okay, you guys are at fault, if they had looked inward, then we could have had a true reconciliation. People could have come together. But that's not what happened. The chiefs made a decision right early on that what they were going to do is extract as much as they could out of this reconciliation process. In other words, they saw dollar signs. When we were saying reconciliation, that's a meaningful thing, and let's try to get Canada to a point where Indigenous people could do better in Canada, the chiefs were saying, how do we make money out of this? Now, that's a very crass, perhaps crude, and I'm sure that there are many of the chiefs who were trying to do better than that. But they used it as a money of extraction, and as a method of extraction, and trying to get as much as they could. And I think we're now at a point where most Canadians are very, very cynical about this whole idea of reconciliation. Something that was originally a good idea has has turned into something that's actually threatening to take their property away. So things are not at a good point now, and we do have to find some type of solution. How we're going to come out of it, I don't know. But as I mentioned before, my worry is that we're going to get into this situation where there are going to be more and more demands on the taxpayer. Our best and brightest are going to be moving south instead of staying in Canada because their tax rates are going to be going up so much. So we have to find a way out. But what we're doing right now is not working.
All right. Well said. So we need to find a way out. And I think earlier, Brian, as well, you said a very important word. And how is this sustainable on all kinds of levels? And I think, Marco, your principal point is, gosh, does this really sound like a respectful, equal relationship, or is it frankly putting the world upside down in terms of our future and how we run? I do want to share a fascinating clip that just came out the other day, and it has to do with a court case in Frog Lake First Nation. And Frog Lake, I believe, is on the Alberta side, right by Saskatchewan. And it's a fascinating case.
I want to see corruption go away in our community eventually. I know it's going to be a process.
Member of Frog Lake First Nation near the Saskatchewan-Alberta border, Hans McCarthy, took Indigenous Services Canada to court with support from the Canadian Taxpayers Federation. APTN National News reported in 2021 that Frog Lake's trust fund, which held $102 million in 2013, had dropped to just $3 million by 2019. Following that report, McCarthy filed an access to information request for Frog Lake Band Council resolutions to see where that $99 million went. But Indigenous Services Canada refused to release these records, leading him to argue in court that Ottawa has a duty to disclose this information to band members. McCarthy says he knew there was the possibility the funds were misused, but being unable to see how money was spent at the time was an emotional experience.
The first emotion was anger. It was overwhelming. I've always known that the community was not functional because I have uncles and aunties and we're all related in the community. We all talk. We know what goes on in our community. But the thing is that we didn't have the documentations because Chief and Council never shared that.
The case was heard in federal court on September 10th in Vancouver. The court ruled in McCarthy's favor on November 20th, stating the documents requested must be handed over within 30 days. McCarthy hopes seeing the Band Council resolutions will shed light on where the money went and help inform people how to vote in future elections.
In good public policy, we always emphasize good accountability and transparency. Surely the book should be open, and by golly, Mr. McCarthy, in this case, won his case against his First Nation. And it, by all accounts, it seems like there was a lot of money at stake in this fund, some $100 million if the report from APTN is accurate. But what does this mean in this larger context that surely our vision for the future is that all Canadians, including Indigenous people, live with good governance? How is this related to this theme that it seems like there's a kind of I don't know if it's a different set of rules. Like if you were in local government, you'd never see this. I mean, you would see problems as well. No government is perfect. But how is this part of that theme where we're creating, frankly, a mess? We're empowering almost a kind of a bad governance system across this country, Marco.
Well, bad governance is nothing new to human beings. The Scottish philosopher David Hume said that we ought to tolerate a certain amount of corruption because if we go after every single little act of corruption, we would essentially end up with a police state. So the issue is not whether there is lack of governance, but whether the lack of governance is institutionalized. In other words, that is absent altogether. And that is often what we have in Aboriginal communities. But, we're not exempt ourselves. Look at, the Green Slush Fund, so-called, right?
Indeed.
Billions
Yes.
and billions of dollars spent, given to cronies and friends. And there was an attempt to have a certain kind of governance institution oversee it, and we shut down Parliament, and the Liberals obscured and obfuscated and everything else. So there is something in the culture at the moment that has rendered these sorts of things permissible. These things have been going on. Those of us who have seen this, and Brian would have seen plenty of it coming through his courtroom in some Aboriginal communities, but it's now also spreading through the culture everywhere else. So we have a larger problem than just that community.
Well said. Brian, is it time to bring back the Financial Transparency Act for First Nations?
Yeah, what goes around comes around, I guess. It was because of people like Mr. McCarthy, in large part, that Stephen Harper brought in the Financial Transparency Act, and it was actually in place for the last part, I think, the last year or so of his tenure. That's where we found out, for instance, that there was a chief making more than $1 million a year, and the expense accounts were unbelievable. And then, of course, the first thing the Trudeau government did when they came in, it was to shut it down. That act is still technically on the books, but it's not doing anything. Now, by shutting it down, they could certainly, avoid. The chiefs could avoid embarrassing news reports, etc. But at what cost? People like Mr. McCarthy, people of ordinary members of Indigenous communities, are finding themselves totally ripped off by unscrupulous people. So, of course, there should be transparency, and they've got to find some way of bringing that type of legislation back, for sure. Yeah.
All right. So we've covered a lot of ground in our discussion today. And as we kind of wrap things up, we're going to stay tuned to this, obviously, this decision. And we're going to try to continue to be as informative as possible. In the meantime, Marco and Brian, do you have any advice for citizens? What we should be on the lookout for on this issue, or what we can do to make a difference in this issue? I mean, beyond being informed, frankly, how do we make a difference? I mean, I sense a lot of concerns of Canadians for our country. We want it to be strong. We want it to be both prosperous, but also a place where people have the freedom to live out the Canadian dream, to be able to, well, in this case, acquire their property and move things forward with their family. What can citizens do? Any words of wisdom there, Marco?
Well, I hate to keep coming back to the same well for this one. The antidote to this sort of thing is active political participation. If we all stay home and not mind the store, as it were, then there is going to be all sorts of shenanigans, and perhaps even worse than what we're seeing today, if we don't become involved, if we don't pay attention. So demand from participate, and there's many different ways to participate in public life. You don't really have to run for office to participate. You can be involved in so many different ways, through nonprofits, through charities, through political parties, by all means, but they're not the only way. But ultimately, citizens who are active, who can signal to the elected officials that their rights are inalienable, that their rights cannot be taken away by a parliament or a group of politicians, or even a minority giving itself these sort of superior rights. So it comes down to this is a political problem. It's not a problem that came from Mars. And so it must have political solutions. And in order for the solution to work, it must include, in a democracy, the greater numbers of us. And if you want to be included, then you have to raise your voice and say, here I am.
Well said. Speak up. Over to you, Brian. What are your thoughts? What can we do as citizens?
I'll put it even more bluntly. Don't trust the government. That moment came for me during the lockdown. At one point, our public health officer told us, "Don't go outside to exercise because you get COVID," or something like that. I mean, it was so nonsensical. And at that point, it just came home to me. No, there are reasons why we have to take care of ourselves. We've got to hold these people to account. Don't just accept the idea that, well, they're the government and they're going to be on your side. If I was in BC right now, and if I owned property in Richmond in that 800-acre area, I think I'd say, these people are not on my side. They're on somebody's side, but certainly not mine. So just echoing exactly what Marco said. We have to be involved, we have to pay attention, and we have to stand up for our rights. And don't be afraid of people calling you names. That'll happen. But don't be afraid of that. Stand up for your rights.
Right on.
One of my friends who hosted a radio station, a radio show in Halifax, used to close his shows by saying, "If you are not enraged, you are not paying attention."
Wow, that's quite a powerful phrase there. So speak up. We've heard a lot of good advice here in terms of both policy insight on this complex topic, but what you can do as well. And I have some suggestions, and one of which is to share this program. Get informed, but share it with your loved ones and your circle of people, because surely an informed citizenry is the foundation for a brighter future and for intelligent, thoughtful action that will make a difference in this country during this historic time. I want to tell you as well, support the Frontier Center. This is a nonpartisan organization. We believe in seeking the truth and trying to serve Canadians. So please don't hesitate to give and support what we're doing. So please, we do appreciate your support. And in the meantime, I want to wish everyone well, and thank you very much, Brian and Marco, my friends, for joining us. We certainly appreciate your analysis and time for spending with us today.
Okay.
Thank you.
Bye, Marco.
There is a publication coming up next week, and it's one of Brian's essays, an analysis on the Cowichan and connecting it to some of what is going on in Manitoba. So be on the lookout at the Frontier Center for Public Policy's website for that.
Very good. So stay tuned. And speaking of next week, I did want to tell you that I will be on assignment, so we will not have a live program next week, but we'll definitely be at it again on our weekly basis. But, in the meantime, I wish everyone all the very best as we wade through these important issues together as fellow Canadians. And I remember the famous statement by a late president who said, "Ask not what your country can do for you, but what you can do for your country." So speak up, get involved as citizens. That is our duty and responsibility. And if you are silent, then you're part of the problem. So on that note, thank you very much for joining us and have a terrific day.
Bye-bye.
Here at Frontier, we don't receive any government funding. We are nonpartisan and we work for you. Find out more and support this important work by visiting fcpp.org today.